and welcome everyone. As Jen said, I am Liz Hill. I am the Director of Communications and Development at MWI, a dispute resolution firm based in Boston, and also serve currently as Chair of the ABA section of dispute resolution. Today, I have the pleasure of moderating a conversation with David Hoffman about his new book, The Art of Impasse-Breaking in Mediation. I suspect many of you know and admire David, and which is likely why we have so many people here and such a fantastic turnout. But I'd like to take a moment to introduce him just the same. David is the John H. Watson Jr. Lecturer on law, sorry about that, at Harvard Law School. And he teaches mediation, diversity and dispute resolution, and legal profession collaborative law. He's also an attorney, mediator, arbitrator, and founding member of the Boston Law Collaborative, where he handles cases involving family, business, employment, and other disputes. David also happens to be a past chair of the ABA section of dispute resolution and the author of several other books on conflict resolution, including Bringing Peace into the Room. Maybe bridging is the theme in that book. I don't know. I'll have to check it out. David and his wife, Leslie, live in a co-housing community in Acton, Massachusetts, and they have 5 adult children, as well as an adolescent cat and a rescue golden retriever from Serbia, which is probably a whole other discussion we could have someday. So David, welcome. It's such a pleasure to see you. I'm excited to talk with you about your new book and your ideas behind it. Quick administrative note, the book, if you're not already familiar, is available at shopaba.org. And I know Jen will be dropping that link and a discount code into the chat for that. So as Jen said, before we get started, just real quick, feel free as we go along to drop questions into the chat. Jen and I will both be keeping an eye on that, and we will try to weave some into the conversation as appropriate, but if all else fails, we will save some time at the end to get to as many of those questions as possible. All right, David, are we ready to get started?
Yes, and
All right.
thank you so much for the invitation to be here today, and a big thank you to Section for publishing the book, The Art of Impasse-Breaking. It was a lot of fun to write, and the Section was great to work with in terms of getting it out there. And I want to thank the people who are in the Zoom room. I looked around in the gallery view, and there are some folks here who have been my mentors and friends in the world of dispute resolution. So thank you all for being here.
Yes, well, thanks for those kind words. All right, let's dive in. We've got a lot to get through, and we've only got an hour together. So the first question, David, I want to talk about is every mediator has experienced that moment, right? That moment where negotiations, they just grind. They grind to a halt. The parties get dug in, the energy in the room drops. Maybe people start to wonder whether agreement's ever going to be possible. So your book is all about what mediators can do in that moment. So how would you describe the book in a nutshell?
So there's a story that Bill Urey tells in a TED Talk, but it's a story that goes way back, at least to the 18th century, called The Story of the 18th Camel. And so I'm going to share my screen to tell the story because I think the story captures the essence of what I think we mediators are trying to accomplish when we're in that moment of impasse and trying to figure out what to do next. So the story, the way the story goes, it's an inheritance dispute. And it arises because the parents have died and they have 3 adult children, and in their will, it says that the oldest gets half of the estate, the middle child gets 1/3 of the estate, and the youngest one gets 1/9 of the estate. And can you see the slides okay? Is this working?
Yep,
Liz?
it's working.
Okay, good.
Perfect. We see it. It's great.
Okay, fabulous. So, and here's the problem. The problem is that the parents' estate consists of 17 camels. So when you try to divide half and 1/3 and 1/9, it just doesn't work. So of course, the solution to the problem is to hire a mediator, and they do. And the mediator arrives riding her own camel, and she decides to donate her camel to the parents' estate. And so now there are 18 camels. This works great because when the kids do the math, the oldest gets 9 camels. The middle child, getting a third, gets 6 camels. The youngest, getting a ninth, gets 2 camels. And here's the interesting thing, mathematically speaking. When you add up 9 and 6 and 2, you get 17 camels. And so that means there's one left over, and the kids give the 18th camel back to the mediator. Now, for those in the Zoom room who are trying to figure out the math on this, I asked ChatGPT to create a pie chart for me to illustrate the point. So what you see in this pie chart is a division of a half, a third, and a ninth of a whole. And what you see in the red wedge of this pie chart is that there's a surplus. In other words, if you add up a half and a third and a ninth, you don't get a whole, you get something less than that. You get 17/18 of a whole. So there's 5.6% of the total estate that's surplus that hasn't been allocated by the parents. And by donating the 18th camel, at least temporarily, the mediators create a situation where after the oldest gets 9, the middle gets 6, and the youngest gets 2, each of the three has gotten a bigger slice of the pie than they would have had otherwise. So they're all three of them are better off. By the way, anyone who wants to dig more deeply into this, you can find a web page on Wikipedia about the 17 animal inheritance puzzle, which was created by Mullah Muhammad Mahdi Naraki, who is an Iranian philosopher of the 18th century. Or you can check out Bill Urey's TED Talk called The Walk from No to Yes, in which he retells this story. So in answer to your question, Liz, my view is that what we're trying to accomplish as mediators when we're facing an impasse is to find the 18th camel. What is it? It might be some emotional piece of the puzzle. It might be some missing information. It might be a missing party. We have to, the first step when you hit impasse is to diagnose what's the settlement barrier here. And often, I would say perhaps more often than not, the answer to that question lies in the human heart, in the emotional resonance that this dispute has for people, and figuring out what that is a big part of the art, and I emphasize art, of impasse breaking.
Excellent. No, I love that you frame it as art. And yes, really, like you say, diagnosing what kind of issue are we dealing? What's getting in the way? Is it that structural, psychological, emotional, or something else? Um, so so you've done a great job demonstrating how that shows up in mediation and how we can expand that pie, so to speak. Before we move on to the next one, if you had to summarize that in one sentence, or what's the key takeaway you want people to leave here with from that fabulous story?
I think the question we have to ask ourselves is how are we going to add value in the situation? And it may be being a really good listener, or it may be someone who helps generate ideas. But in the world of business, the question that business people ask when they think of a new idea, a new project, is what's the added value here? And we're dealing often with very capable people. How are we adding value to the situation? What's our 18th camel?
Excellent. Yes. How are we going to help them see that path forward? Excellent. All right. So the next question, David, is more about the why. You've been mediating for decades. You've written other books on conflict resolution. So what led you to write this book that's specifically about impasse breaking?
Well, one of the things I mentioned in the book is that I used to be a woodworker. So for 7 years before I went to law school, that's how I made my living. And I don't think I was a particularly terrific woodworker, but good enough to make a living. But the thing that I really liked about woodworking was the were the tools. It was really fascinating creating jigs to do various kinds of projects. And I had a Swiss Army knife that I carried with me literally every day of my work life as a woodworker. And I loved the fact that this was called a Swiss Champ, Swiss Army knife. It had 33 different functions. And I thought when I became a mediator, I thought that's what I need. I need a Swiss Army knife because all kinds of problems present themselves in mediation. And so over the years, doing trainings and workshops and teaching mediation, including teaching with some folks who are in the Zoom room, um, I developed, a set of slides about the different tools in the toolbox. And one of my colleagues at Boston Law Collaborative, David Sachs, said the Bar Association needs an article for the State Bar Association needs an article for their journal. Anybody have an article they want to write? And I thought, I'll write an article about these impasse breaking techniques. I've been teaching about them for years. I never wrote it down. So I started writing and it got longer and longer. And pretty soon it was completely unacceptable as a journal article. It was just unwieldy. So I knew it was either going to become a long article or a short book. And it became a short book. And it's my little contribution to the world of dispute resolution, 60 different interventions that mediators can use. You can use the table of contents as a checklist. If you're kind of struggling to find your 18th camel, hopefully it's somewhere in there. And I just want to add one further thing. I view the book as an invitation for dialogue with people in the field. I'm hoping that people will write to me with their stories of their 18th camel and some technique that they've come up with. I've already received such input, and I've credited in the book ideas that came from fellow mediators. And I'm eager to hear from folks in the Zoom room. If you've got a good idea, I'd love to put it in the next edition with credit, of course, and to keep that conversation going.
That's excellent. Well, we're grateful. We're grateful that you've created this. And I like that you call it a handbook because what you describe is that, right? It's a resource that people can use. And maybe you don't read it front to back. Maybe it's you move around as you need to. And I love how you describe the metaphor, the Swiss Army knife, because it really goes with one of the themes that I took away from the book, which is fit the fuss, right? You got to identify what's going on here and then be adaptable. Use the right tools in the right situations depending on what's happening. So I think that's all great. And I just want to follow up on something you said just now about the reactions you've received. Anything that you want to share, like reactions you've received from lawyers or others who have read the book, maybe before doing a mediation? I don't know.
Yes, well, I've already gotten some positive feedback, and in a tough mediation last week, which I'm going to describe a little bit later in this
Okay.
discussion, I gave the parties and counsel copies of the book, and said, let's, if we get stuck, let's, look at it together. I've gotten very nice feedback, and before actually publishing it, I sent a preliminary draft to a number of mediators. So I've gotten feedback that this is uh, a bite size. If you're going to put 60 different interventions in a book, plus a whole bunch of other ideas, you've got to be careful about the length. And so each of these interventions is described in about a page or so. And I think that my goal was to add to the utility of the book by making it brief and
Mhm.
bite size and easily accessible.
Yeah, that's smart, bite-sized, so you can read it, digest it, use it immediately. So the book also introduces, and you've touched on this a little bit, a wide range of tools that mediators, can use when negotiations stall. I don't know, are there any more that you'd like to elaborate on, two or three that might be especially useful or maybe even surprising for people here in the audience?
Sure. One of the tools that I learned about from a political scientist is called the adjusted winner auction. So there's a section in the book dealing with auctions. If parties own a business or a piece of real estate or a whole bunch of stuff, sometimes the answer is to have an internal auction between the parties, see who's the higher bidder. Sometimes it means putting it on the public market, and because that may yield the highest price. Um, but if you're going to do an internal auction, and there are many advantages to that, privacy, for example, and control, um, the adjusted winner auction is an interesting innovation, and it works the following way. Let's say there's a couple and they're dividing up their belongings, and there are maybe 20 belongings that are quite valuable. There may be a piano, there may be a wonderful sound system, there may be a boat, whatever. They each fill out a bidding sheet separately, and they put on the bidding sheet what they're willing to pay to have that item. And then after they've filled out the sheet, they compare their bidding sheets. And let's say one of the spouses put down $5,000 for the piano, and the other one put down $2,000 because they don't really care that much about the piano, but they know it has value. The one who bid higher gets the piano, but not at 5,000, at 3,500, which is the average of the two numbers. So that spouse thinks, I got a bargain. I got this really nice piano for 3,500 instead of five. And the other one is going to get half of $3,500. So they're getting more for it than they thought it was worth. And right down the line. Now, I don't use this every single day, but when it's needed, it works really well. One other technique, and this is one I actually came up with myself. It's a three-step appraisal process. And it works with the sale of a business, or not the sale, but the valuation of a business, real estate, or other items. And we use it in mediation. So the parties sign an agreement that they're going to have a three-step appraisal, where the first step is they jointly hire an appraiser, and the opinion is non-binding. After they get that opinion, they confer and negotiate and see if they can agree on the price. If they can't, they go to step two, which is to jointly hire a second appraiser. Now, part of the ground rules that the parties don't lobby these appraisers. They only communicate with them, by email or in writing. So there isn't any attempt to influence the outcome. After the second joint appraisal comes in, the parties confer, see if they can negotiate a resolution. And if they can, great, they're done. But if they can't, they go to step three. And after step three, they will be done, because the protocol that they've signed says that after getting the opinion from the jointly hired third appraiser, if they don't have an agreement, then it's going to be the average of the three appraisals, and they're going to be bound by that. And if one appraisal is more than 15% different from the average of the other two, that one's considered an outlier and it's ignored, and they just average the other two. It's possible mathematically to have two outliers, and so you reject the one that's more of an outlier, if there is one. And I have found that over the years, I've only once had folks get to the third step. They almost always agree after the first step or the second, which of course is the point. We would much prefer that they reach an agreement rather than a resolution that is really taken from their hands. So that's actually a technique that gets used a lot in my practice. But I would say the most well-worn tools in the toolbox are range bargaining, mediators' proposals, case evaluation. So as I mentioned to you earlier, Liz, I want to show a few more slides and do a quick case study.
Great.
I mentioned a case that I did last week, and with changing the identifying information, of course, I'm going to share with you what happened in this case. So it was an employment case, and one of the interesting features of the case was that there was no discrimination claim. There was a CFO who was terminated. But it was a pure contract case. And the issue in the case was whether there was going to be um, severance payment. And the severance payment was a fixed amount. And if the plaintiff won the argument that that he there wasn't cause for the termination, that he was entitled to severance payment, then he was going to get $321,000. Now, one thing that made this case somewhat different is that the employer filed a counterclaim saying that the CFO had been so negligent in carrying out his duties that they were entitled to recover money. As folks in this Zoom room may know, that when you have an employment case with a counterclaim, it tends to get very intense because now the employer is trying to reach into the fired employee's pocket. So the mediation began. We had a pre-mediation conference call with Zoom call with counsel. I got memos from each side, and we began at 9:30. And the plaintiff began with a demand of $250,000. They wanted to stick with their 321, but I talked with them about, and the defendant absolutely insisted they have to come up with a number that's different from their make whole number. So 250, I thought, okay, well, let's see what happens. And the defendant said, well, we'll drop our counterclaim and we'll offer 25,000. But I met with the lawyers, and they were both feeling, their clients were feeling some sticker shock. The numbers were pretty far apart. And so interestingly, I mentioned to them the possibility of range bargaining. And so plaintiff's counsel said, yeah, I think that's a good idea. And so they said, we will come down from 250 to 175 if they'll come up to 100. That's how range bargaining works. It's you're offering a settlement range. And the defendant responded with their own range, said, well, we'll come up from 25 to 40,000 if you come down to 120. Now, people who are not familiar with range bargaining think, well, what's going on? No one is accepting anything. They just keep going back and forth with different ranges. But what you can see is that the midpoint of these two ranges, those two midpoints are now kind of within shouting distance of each other at 80,000 over here and 137.5 over here. The plaintiff at that point decided, you know what, I think we're better off just going to a number. So they came back with 160,000. And the defendant also made what I thought was a pretty healthy move to 70,000. So it felt like we were getting momentum, but then the defendant hit the brake, the plaintiff hit the brakes, proposed 145. The defendant only came up 80,000 to 10,000 to 80,000. And the next move was only 7,500 from the plaintiff, and the next move from the defendant was only $5,000. And you can see if you plot the arc of these different moves, the lines are not going to cross. And I knew that they weren't going to cross because privately in these caucus sessions, the plaintiff said, we will never, ever come below $120,000. It's just not going to happen. And the defendant said, we will never get up to $100,000. That's just not going to happen. Now, I didn't ask them their bottom line. This is what they volunteered. But the plaintiff looked at this $5,000 move and said, this is not going anywhere. And they suggested that I make a mediator's proposal. Now, I had explained to them a while back that I'd be willing to do that if it was helpful. And the defendant said, sure, let's do that. So anybody in the Zoom room who has a calculator probably knows what the mediator's proposal is going to be. It's not always right in the middle, but there were really hard feelings in this case. And this mediator's proposal came late in the day. We were actually into supper time at this point. And everybody was really concerned about losing face. And I concluded that the mediator's proposal needed to be exactly in the middle of the last offers. And you can see that this number, $112,250, is very close to the midpoint, to the average of the two midpoints, going all the way back to the range. Now, the ground rules for mediator's proposal, as I think most people here know, is that I get the answers privately, confidentially, and I don't disclose what the responses are unless I have two yeses. If one side says yes and the other side says no, I just report there's no settlement. That way, each party can take the risk of saying yes, and the other side won't know they said yes unless they too said yes. In this case, both said yes. The mediator's proposal was accepted, and by um, uh, somewhat late in the evening, it was 8:30. We wrote up a memorandum of understanding, and we were done. Now, some people might wonder, well, what about the case evaluation part? Well, I'll just mention briefly why the parties, at least the defendant, wanted a case evaluation along with the proposal. And that was because they were going to take whatever they paid to settle this case to the lawyers, their previous firm that represented them, and a firm that gave them what they thought was bad advice in documenting the cause that they believed they had. So they were going to sue for malpractice, legal malpractice. And so they wanted a justification for the number they were paying. And in the mediation, we had a conference call with the other law firm and the lawyer representing that law firm and see if they would kick in some money. And we couldn't, the defendant wasn't able to get enough money from their old law firm to do the trick. There was another stakeholder here, by the way, two other stakeholders on the plaintiff side, namely the plaintiff's lawyer, who was in this case on a contingency basis, pure contingency. And there was a litigation funding firm which had provided funds to the plaintiff while he was pursuing this litigation. I mention this because this is a case where three very commonly used impasse breaking tools, range bargaining, mediator's proposal, and case evaluation, were needed to provide the 18th camel. I'll just point out that there was only one joint session. The CEO of this company did not want to be, she told me she did not want to be in the same room with the CFO. There was no, and he didn't want to be in the same room with her. There was no love lost between these folks. We had 18 separate caucus sessions, and then we had 4 sessions. You see them in gray bars here with both attorneys together. Some might be wondering, well, is this a pure distributive bargaining case? Was there any effort to get an apology? Were there other non-monetary terms? And there were no apologies coming from either direction. But we did have things like non-disparagement, confidentiality, no admission of liability, non-solicitation agreement, and non-disclosure of company information. So there were some non-monetary terms that were relevant, but basically this was a money deal, and I had to use a lot of tools to get it done.
That's a great, no, I love that. It's a great example. Thank you for the illustration too of using the different tools and how they can work in concert with each other. I do see we have 3 questions in the chat. So Marjorie, Judy, Brenda, if it's okay, well, actually, David, maybe we should try to tackle some of these now. I was going to hold off, but maybe let's just dive in. Why not?
Sure.
So Marjorie asks, what's a technique to obtain more money from an insurance carrier which has a different objective, i.e. limiting the payout, than the parties in the dispute who might have more settlement funds?
Yeah, great question. And often if the stakes are significant, there needs to be a mediation within the mediation. In other words, the insured needs to have a negotiation with the insurer. And often what they do in that negotiation is they hire their own coverage counsel because the lawyer who's been hired by the insurance company to represent the insured, they can't participate in that kind of bargaining. It's just not ethically permitted. And so now it's gotten kind of complicated because we've got an insured, their coverage counsel, in-house counsel for the insurer, negotiating the coverage. And the leverage here typically is, has there been any unfair settlement practice by the insurance company? In other words, if liability is reasonably certain, have they put enough money on the table to satisfy their responsibility as insurers, their duty to engage in a reasonable negotiation? So that's the leverage that exists to motivate the insurer to step up, or for the insured to say, well, I get their point. They've, filed a reservation of rights letter. They might even be denying coverage. Sometimes that happens in the middle of a dispute, and the insured might decide to put in some money of their own. So it's a very dynamic process, and of course, this happens outside the hearing of the plaintiff, and
Hmm.
then we have to figure out, will the fees be divided equally, the mediation fees, because I'm now spending a lot more time on the defense side of the case.
Oh, that makes sense too. Yeah, I hadn't thought about the fee part. Yeah, good point. Okay, thank you for that. I'm gonna skip Judy. I'm gonna hold off on yours until the end. That's just because that's a probably more general, all-encompassing kind of question answer. Brenda asks about range bracketing negotiations and how many parties think of that more as split the difference. That the midpoint is the offer. What suggestions do you have on how to better use ranges?
So I think the challenge with range bargaining is to let people know that I, as the mediator, am making no assumptions about the meaning of the range. I don't assume that because we could calculate the midpoints of the various ranges, that that's the real number. I don't believe that is the real number. And I would say many times after range bargaining, if the parties want a mediator's proposal, my proposal isn't always precisely in the middle. This case in some ways was kind of an outlier, the one I just showed, because what I'm really gauging when I'm making a mediator's proposal is what is the point of resistance for each side, and it may not be symmetrical. In this particular case, it was. But another component of making range bargaining useful is to make sure that all the participants get how it works and are okay with how it works. Because some people just find it kind of like number mumbo jumbo, and it's just magic, some kind of magic trick. It's not. What's happening is the bookends are moving closer, and they're moving, and both the top of the range and the bottom of the range communicate something about where each side is willing to go.
Yeah, so you're learning, you're gaining information by seeing how each participant is moving in either
Yeah.
direction. And then finally, I'll touch on this one, and then we'll move on. But Richard asks about the mediator proposal split, and whether that is an evaluative process. Do you evaluate the case?
Great question. So what I do before doing mediator's proposal, I actually have a little slide deck that I show the parties and the lawyers to make sure that they, excuse me, understand the difference between case evaluation, which is prediction of what a court would do, and mediator's proposal, which is a prediction of what the parties will do. And
Mm,
those two may be related to each other, and no doubt they are, because the parties, in thinking about what they're willing to do, are influenced by what's their malatna, their uh, most likely alternative to a negotiated agreement, which is different from a BATNA or WATNA, best alternative, worst alternative. If you tried the case 10 times, what would happen? That influences, but it's not the only influence, obviously, in what parties are willing to do.
hmm. Definitely. Okay, so I do see more questions coming in. I am going to pause on the questions for a moment so we can move forward, and we will save some time at the end to come back to them. So I'm taking notes, everyone. I won't forget you. So David, take a break for a moment, grab some water. I want to ask the audience a quick question. So one of the techniques, and maybe if you've read the book, you know what I'm talking about, that David talks about in the substantive interventions. I think it's like chapter 3. I think it's the last one, number 30 in chapter 3. But he introduces and no cheating. So if you have the book, no looking, no using the internet. But I think it's a fun idea. At least when I read it, I thought this was fun because I had never heard this word. But the word that he uses to describe this technique is called lagniappe. And maybe Jen, you could put that in the chat for me. It's LAGNIAPPE. So I'm just curious, who's heard that term before? Who knows what that is? Go ahead and since we have 100 something people, let's use the chat. Go ahead and put it in the chat if you know what that is, or you've used that, or you've heard that term before, because it was new to me. Ah, Ed, nice. A little something extra. Excellent. Thanks, Jen, for putting that in there. Yes, Ryan's got it too. Cajun for something extra at no cost. South Louisiana all the time. You use it all the time, Shannon. Okay, I love it. Wow, lots of input here. So some people don't know, a lot of people do know. So I guess I'm behind the curve on this one. But okay, so David, your break is over. Back to you. Thanks everyone
Yes,
for participating in that. Um, how do you explain it and how does it show up in mediation?
yes. So I got this idea from colleague Cliff Handler, an example of people writing in to me with their settlement ideas. And he described a case that was deeply at impasse. And uh, one side decided, even though it wasn't their turn to make a move, they were just going to, without any expectation of reciprocity, they were going to throw another $25,000 in. And the way Cliff described it, it's sort of like the 13th bagel in the bag or the 13th donut. Um, and it just creates like a good feeling. And the other side thought about it. They decided to reciprocate. And now we had a virtuous cycle going, and they got the case done. And so I've seen this happen in mediations where sometimes it comes completely out of the blue, and it could be an apology or it could be something else. I had a case involved, and it's a case mentioned in the book. Um, the There was an uncle and a niece. It was a sad case. The uncle had lost his sister to cancer. The niece had lost her mother. But their family relationship had broken down, and the in the mediation there was an apology because the uncle was the executor of the estate, and he had not done a good job. He had really been very slow, and there was a claim of malpractice because he was a lawyer, a claim of negligence. And the thing that he most wanted, they figured out the money part of the case, but the thing that he most wanted was to reconnect with his niece. And he was also hoping that she wouldn't report him to the Board of Bar Overseers, which he could have done. There's nothing in the contract that would have been enforceable. They didn't even, bargain for that. But I met with the two of them without their lawyers, and they had a lovely, heartfelt exchange. And he said to his niece, I really want to be family again. And I'm just wondering if you could ever, and he was about to say the word forgive. And she held up her hand like this. And I thought, oh, this doesn't look good. And she said, I've already forgiven you. And then she added the lanyap, which is, I'm not going to file anything with the Board of Bar Overseers. And he got very tearful, and then she got very tearful. And so, of course, I got very tearful because that's kind of how I roll. I cry very easily. And it's getting a little verklempt right now. Uh, but so the lanyap isn't necessarily $25,000 or some material term. Very often it's coming from the heart.
I love that. What a nice story. Thank you for sharing that. And it's a great example of what that might look like. I'm smiling because I'm looking at all the different comments coming in, and Kathleen, I do see your question. We'll save that for the end as well. But I love some of the comments. I'm learning a lot about our audience here. Someone heard it for the first time because it was a theme of their friend's wedding recently. Um, Others say it's a bar they like to go to. So I don't know. It's all sorts of all sorts of fun answers. I encourage everyone to check out the chat. Okay. Well, thank you for that. Oh, I'm sorry. Take a moment, David. I know it's emotional. It is mediation. There's a lot of emotion in mediation. I
Yeah.
think people sometimes forget that it's not always about dollars and cents. People's feelings and their families and their connections are at stake, and
And
important. Go ahead.
and one of the things that I'm noticing in this moment is that when the parties can be vulnerable with each other, it really makes a difference. And as mediators, we can model that kind of vulnerability. We can, you don't want to overdo it. In some cases, it would be completely inappropriate. But when you're dealing with a complex mix of money and emotion and family relationships and so forth, um, uh, being authentic, being genuine, and if we're feeling something, letting people know that, I think is, part of what makes mediation work.
Absolutely. And I think Jennifer Sullivan in the chat mirrors what you're saying, David. She says, thanks for modeling that emotion. It's okay for us as mediators too.
Mhm.
And I think that's spot on. Okay, so I'm looking at the time. We've got about 15 minutes. Time always goes by so quickly. So let's get to a couple more of our questions, David, and then I want to make sure we leave time because there's some in the chat as well. So the next question really comes from the psychology of impasse. One of the themes I think that runs throughout the book, and you've touched on it already, is that selecting the right impasse breaking technique does require understanding the psychology behind what's going on. And you kind of started us off with that. But do you want to say more about that? Are there other examples? I know you and I, when we met, we talked a lot about the family systems theory, and I know there's some other examples. So I just want to open the door for you to talk more about that.
Sure. Uh, so, so often there are emotional or cognitive roadblocks that make it hard to
Mike, the
settle a
cleaning
case.
lady's asking if she can come early between 1:30 and 2.
Oops, Jen, can we make sure everyone's muted?
Yeah, right.
Absolutely.
Well,
Yeah,
Sorry about that.
it's all right. So let me give an example. Daniel Kahneman, in his book Thinking Fast and Slow, which I know many people here are familiar with, talks about system one thinking, system two thinking. System one is our intuitive, rapid, sometimes almost unconscious processing of ideas and decisions. System two is our deliberate, slow, rational, thoughtful system for processing decisions and information. So I'm sitting in a caucus room with a guy. He's in his 80s. He is the founder of a foundation. He generously funded this nonprofit and hired professional staff. And he became, there was tension between him and the board. And essentially, they said he had to go. He had behaved in ways that caused them to feel that he could not continue being part of the foundation. And he really resented it. He was really angry. I said, "What do you really want?" He said, "I want the current CEO's head on a platter, so to speak. I want him fired. I want the CFO fired." And I said, "I don't think that's going to happen." you know. And so I said, they've offered a lot of money. I think in this particular case, they had offered a severance of about $750,000. And he was not happy about that at all. So I said, I've got an idea. Why don't you, on a yellow pad, make a T chart? And I want you to write in the left column the reasons why taking the settlement would be a bad idea. And in the right column, I want you to write the reasons why this $750,000 proposal would be a good idea. And he marked the pad, and as he picked up the pencil to write, he paused and he looked at me and he said, "It's really hard to be emotional about this when I have to write this down." He said, "I get it." And they wound up settling the case. And what happened in that moment as he picked up the pen is he made a transition from system one anger to system two rationality. So, and Bill Eddy, who's a mediator, lawyer, clinical social worker, has a technique, which I think is great. When people are getting highly emotional, he says, "I get it. So what's your proposal?" In order to formulate a proposal, we have to switch over to system two. There's another psychological element that is reflected in case evaluation mediator's proposal, which is reactive devaluation. When one side makes a proposal, the other side thinks, "What's the catch?" You know, they think that the other side, must be hiding the ball in some way. And so, very often, when mediators make proposals, we overcome what's called reactive devaluation, the devaluation of the other side's proposal because of the source of where it's coming from. So those are cognitive barriers, but the ones that I'm finding most interesting right now and most useful are the tools for getting to the heart of the matter. And I mean that both literally and figuratively. And I'll use the example of that case study that we just looked at. When I talked with the CEO, I said, "You're not willing to go above a certain number. I get that. But what if you could get money from the malpractice insurer? What if you could get the money from someone else? Would you be willing to go over $100,000 if you were going to be reimbursed for it?" And she said, "No." And I said, "Why not?" And she said, "Because it wouldn't be fair. This claim is really bogus. And I want to, stand up for what's right. I don't want to reward what I view as greed." Now, and that's a very understandable reaction. We see this in mediation all the time. And so I said to her, and this is using the internal family systems idea that we all have a mediator within, what we call self-energy, and that we have parts. So I said to her, "I get it. There's a part of you that wants to stand up for what you believe is right. And there's another part of you, the CEO part of you, that's worried about the bottom line and wanting to get this litigation off the books because it's going to complicate the company's life as you attract new funders." And so I'm just wondering if you can be in touch with the mediator inside you to notice these different parts and come up with a wise resolution. And she found that very helpful. And eventually, as you saw in the case study, they wound up settling at 112,500, which is 250, which is a number that she said they would never get to. But she did the internal mediation that helped her come up with, I think, a wise and I hope a regret-free resolution. So I want to say one last thing in response to your question about the psychology.
Yes.
When I showed an earlier version of this book to a friend and mediation colleague, Larry Susskind, he said, "I get it. It's good to have all these tools." He said, "The thing that's really hard about the art of impasse breaking is knowing which tool to use."
Yes.
And for that, I think figuring out the psychology of the situation and using our intuition, listening so carefully that we're hearing not just the words, but the music and what people are sharing with us, that's where the art really comes from. And I wish I could give a cookbook style
I was
description
going
of
to suggest
how, yes,
that.
of how we access our intuition. I
Yes.
think it comes from experience and being as fully present with people as we can be.
No, I'm glad you said that because that's what I just made a note to myself that, ooh, we need another book that has that decision tree, right? If this, then this, right? To help people figure out what tool to use when. But maybe, yeah, there's probably a lot more to it than is that's oversimplifying. Well, no, thank you for all of that. And I can't agree more about addressing the emotion, right? People can't, as we all know, physiologically can't think clearly, rationally, reasonably when there's a lot of emotion. So embracing that and addressing it. And I love the mediator within because it allows someone to actually have almost like a different persona, like wear a different hat, which can remove them from some of the emotion that's going on. All great strategies. I know you have so many stories to tell, and I know our next question was going to dive into a few more. I'm going to encourage everyone to read the book and hear those stories. For the sake of time, we've got 8 minutes. I want to skip to something, David, that I know I shouldn't say I know. I believe you want to talk about, which is the pitfalls, right? What are some things that maybe mediators really need to avoid doing?
Yeah, I appreciate the question because there's so many ways we can get in trouble. And the book lists quite a few of them. And, what we often say is if we could sell our experiences for what they've cost us, we'd all be quite wealthy. I've made so many mistakes. But let me just give one example of something that I think mediators sometimes reflexively do. And I think it's a bad idea, which is court bashing. We need our courts. A democratic society has to have institutions that support the rule of law. And we say, oh, you don't want to go. Court is a terrible place to go. Judges are just all over the place. I think we have to be very careful about the kind of reality testing that we do. There are certain cases that should go to court, that need to go to court. And I think that we make a mistake, not just as mediators, but as citizens, when we encourage disrespect for the courts. A second thing is sometimes people say, well, I've got this proposal I want to make, but I want you to make it as if it were your proposal. That is dishonest. The ABA has recently issued a formal ethics opinion telling us what we should have known even without the opinion. We don't do that. We have a duty of honesty. And so there are ways to frame proposals to overcome reactive evaluation. We don't have to lie and say it's our proposal when it isn't. The last thing I wanted to say as a pitfall is what I call, what social psychologists call group polarization. Interesting phenomenon. When you have a group in one room, group in the other room, as soon as you step out of the room, the conversation tends to ratchet up with a degree of militancy that is really challenging. And so, and social psychologists have noticed that groups will sometimes take more extreme positions than any one individual would take if you polled them separately. And so how do we overcome that? Well, one of them is to do some reality testing. Well, if you do make this proposal, do you think the other side will view it as extreme? What do you think their reaction will be? And hopefully empower the folks in the room who are using system 2 instead of system 1 in thinking about what their proposal should be.
Yes, excellent. Excellent. Thank you for that.
Can I just mention one
Yes,
final story, and then I think let's see if we have time for.
Okay, yes, we've got
questions.
several questions, and
Yeah.
I also want to give you a chance to do a final reflection. So go.
Okay. So one of the stories in the book is about a whistleblower, and he was fired, and he thought there were ethical violations the company had engaged in. The company said, we've looked into it. There are no ethics violations here. And they were very stuck, deeply at impasse. And here's where I found the 18th camel. I was looking at his resume, and I noticed that he had been in the Army for 20 years, and then he took retirement, as people often do. I said, tell me about your Army service. And oh my gosh, he waxed poetic about how great he felt about serving his country and serving the Army. He said, people in service turn square corners because they have to. Our lives depend on it. And then I saw the light bulb go on. He said, when I got into the world of corporate, business world, it seemed like there were no rules. Anything goes. He said, I think I wound up in the wrong place. And with that transformative moment, for him, it wasn't like an exchange transformative moment, but he found something important about himself. And all of a sudden, he was able to negotiate in a way that got to yes and got him a good settlement. So sometimes the 18th camel has to do with getting the parties together. Sometimes it's how each party is looking at their case.
Get them to re-examine and find something different.
Yeah.
Wonderful. All right, I am going to jump to some of the audience questions. Judy's been very patient. She asked this very early on. How, if at all, do you think AI is impacting your approaches?
Great question. And I put in the book a section about using AI to generate settlement options. And I've done this on my own. I have not done it with the parties. So I think that and of course I disguise the identity of the parties when I put information in ChatGPT or Claude or one of the others, because we have to be very concerned about confidentiality. I don't yet feel comfortable enough with it as a tool to bring it into the room and say, let's use this tool together, or even to use it in the caucus rooms. But I think that day is coming very soon.
And some mediators do. So I think it's, learning from each other too, how people are doing these things. Another question, and I'm going to summarize a bit here, is if mediators do too much, you've shared so many great tools, right? If you're using tools, it might be seen as doing too much to help them reach that agreement. Are they then less vested,
Mhm.
in the agreements, which then maybe makes them less durable? How do you see that, and what do you do to address it?
Yeah, it's a great question. We have a saying, and Liz, you may know this saying, that if we're working harder than the parties, we're working too hard.
Yes.
And so I try to, be thoughtful about that and express throughout the process, that this is their decision. I'm just here to prime the pump of option generation and also to try to more deeply understand the parties' interests, goals, and circumstances. So I think there was a time in my practice when I was working harder than the parties,
Hmm.
and I think it's ineffective. So we
Hmm.
have to make sure that this is a team. We, as mediators working with the parties and their lawyers, this is a team effort.
Hmm.
And I'm not trying to impose or inflict my ideas. I just want to do my part in making sure that we've considered all the relevant options.
Great. And then Kathleen asked, do you track the times and movements of each mediation and then evaluate them afterwards? And if so, how do you use that information?
So I do track, and I've done some analysis of moves. Time, of course, is a factor, and many of the mediators in this Zoom room probably have experienced this. If you spend a really long time with one side, the other side is going to expect a really big move when you come visit with them. So you have to figure out the calculus of time and movement. But not only have I looked at my own numbers, but Andy Little has published a book, and I think he may have published it with the ABA. It's called Making Money Talk. I'm looking up at my shelf. And he charted the movement in a whole bunch of cases that he mediated. He put it in the appendix of his book. And it's fascinating. And what it shows is that there's a ratio of 2 to 1 movement by plaintiffs and defendants. But interestingly, when you get to the very bottom of, the impasse moment, that 2 to 1 ratio doesn't always apply. But as you saw in that case study that I showed, 321 was the initial number, and the settlement was 112 and change.
Hmm.
So there,
Hmm.
that 2 to 1 ratio actually did apply in this case. And there are reasons why defendants, I mean, they have externalities that are related to settlement. They're repeat players. There are various reasons why they move less than one of parties, which plaintiffs usually are.
Got it. So hopefully that helps answer those questions. I am going to just take a moment to acknowledge it's the top of the hour. I know people need to get on with their day and get to the next thing. Jen, David, do you have a few moments to stay on, maybe to answer a few more just for the recording so we have it?
Yeah,
Very,
absolutely.
Okay, so for those who do need to go, thank you so much for being here. And if you can stay, stay with us for a few more minutes. Um, Tal asks about and I think I've been saying it wrong, even though you told me how to say it, David. The now I can't even remember.
Lanyap?
Yes,
Yes.
that.
Yeah.
And I think you did give this as an example, but I'll ask it anyway. Does it always come naturally from the parties, or sometimes you have to kind of, suggest it or plant it?
Yeah, it's some of each. It really depends on the context. And, we have to be very careful as mediators to be respectful of what people's boundaries are. I don't want them to have the feeling that I'm, very, you know, uh, easily reaching into their pocket for money. They have it has to be from them. And, I can kind of problem solve with them and say, I wonder what would happen if you did this. But they have to be feeling it. And the lanyap is, in effect, a counter to the ordinary bargaining rules because what's happening is someone is bargaining, is making two moves. Usually it goes back and forth, but the person who's offering something extra uh, has to feel like, I really want to do this, and I think it'll really help the process.
Yes. So yeah, I can go. So either way is the answer. Sometimes it comes
Yes.
up naturally. Other times you might have to do a
Yeah.
little prompting.
And, and
Just
it's and it's not a very common feature of mediations. I think most people in this room would probably acknowledge that.
yeah,
When it
and some
happens,
who had heard of it don't use it. So maybe now they will. Now that you've explained it.
yeah.
Sorry, I didn't mean to cut you off, but some of the
No.
questions that are coming in are asking about materials, if there'll be materials available and how that will be shared.
Yeah. So the materials, everything that I've shared in this conversation, you can find in the book, except for the 18th Camel story, which will be in the next edition of the book. And the case study, if people want to write to me, I'll be happy to send you slides of the case study. And it's D Hoffman, Dhoffman,
I
at,
think, yeah, Jen can put that in the
okay,
chat for
good.
us too. Yeah, I
Feel free
see
to
her
write to me.
typing.
Yeah,
I see
I'll
her
be
typing
happy to,
away.
good.
Yeah.
I'll be happy to send that.
Yes, and it looks like you're getting people are ordering the book, so that's great. People are interested. You did a great job, David. So another question here: can you talk to how mediators unwittingly cause impasse?
Yes, I'll be happy to talk about that. I think that pushing too hard can be a real problem because the law of psychological action reaction, like the laws of physics, if we're pushing, the other side's pushing back. If we're telling them, here are the reasons why settlement is a good idea, they're going to be motivated to come up with reasons why settlement is not a good idea. And that's why the internal family systems model of talking about the mediator within is really helpful because I'm not trying to twist arms. I used to do that. I don't think it's a good idea. I used to be the advocate for settlement. And indeed, sometimes lawyers have said to me, look, I'm the advocate for my client. The other side advocates for their client. You're the mediator. You should be advocating for settlement. And what I've realized is that
Mhm.
that can be counterproductive. And so, what I'd much rather do is use the principle of self determination and empowerment of the parties to consult the sources of wisdom within and come up with a wise choice that makes sense for them. And that relates to the point you were making earlier about working too hard. It's not just working too hard, but it's doing a certain kind of work which the parties are going to resist.
Mhm.
And that's, I think, one of the ways that we can actually cause impasse by getting people more uh, maybe overcommitted to their position.
Sure. Or getting them to agree to something that they're not going to be, that they really can't live with in the end, or they're going to regret. Yes. Okay, great. I'm just looking down our list of questions here. There was one from Helen. Can you discuss the best way to handle a plaintiff's lawyer who has significantly overvalued the case?
Great question. These are wonderful questions. I'm really
Yes.
grateful. So, I've had situations like that, and I sometimes ask, would you be interested in getting a case evaluation from an outside expert, maybe a retired judge or a very senior lawyer? Sometimes they want a case evaluation from me. Um, and uh, but and sometimes they say, sure, that's fine. But very often they don't want the added expense. They don't want to add another cook to the kitchen. They don't want to have to educate some new person. So they'll sometimes ask me to do a case evaluation, but there's a risk there because I may be viewed as taking sides if I do that. That's why in the case study, it was only at the very end that I offered my evaluative opinion and offered it in writing. But here's something I do now that I didn't used to do when I first started mediating. And I think it helps with the over optimistic party. And it could be a plaintiff, could be a defendant. I meet fairly frequently in this last mediation 4 times with just the lawyers. I never used to do that. And joint sessions can sometimes be, problematic if feelings are running high. But the lawyers, in my experience, almost invariably are willing to meet with me in my office and have a heart-to-heart, candid talk. And if one side is being, unrealistic, and I sense that, that may be the case, and of course that's an evaluative judgment too. I want the lawyers to talk with each other about their reasons for optimism and maybe drill down into a specific reason why one side is being viewed by the other side as unrealistic. The defendant might think we're going to get summary judgment. Well, the
Mhm.
plaintiff has got 10 reasons why a court isn't going to grant summary judgment. So I want to hear them and let's explore them together. Sometimes the lawyers can do the reality testing and relieve me of the responsibility of doing it because I may be seen as the enemy if I do it
Mhm.
too vigorously.
Yeah, that makes sense. And it's actually a perfect segue because one of the other questions about using caucus versus using joint sessions. And I heard you earlier in one of your stories examples talk about, meeting with the participants many times before the mediation ever even takes place. And now you're talking about working with the attorneys separately before maybe the mediation takes place. So how do you decide? And I don't know, is there an art to that as well as to when to caucus, when to do the joint session?
Yeah. So this is a decision that we make together with the parties in council. And I offer my thoughts about, for example, let's say one side is about to make a proposal that I think is not going to land well. And I say to them, usually to the lawyer, would you be willing to come down to my office and talk with opposing counsel or go into the room with the other lawyer and the party and present your proposal? And I'm not going to ask them to respond immediately, but I want them to hear it from you, ask questions about it before they respond. And I would say more often than not, people are willing to do that. And I find that bringing people together, even if it's just bringing the lawyers together for face-to-face conversation, adds to the credibility of the proposals that are being made. And that's what I want. If I'm just communicating the messages, first of all, there might be something lost in translation.
Yes.
Second, they might feel like, oh, well, that party has really put the spin on David. He's brought
Yeah,
their arguments hook, line,
right.
and sinker. He must be very gullible if he thinks that's a good proposal.
Right.
No, I want them to have the face to face so that they can deal with whatever reaction or resistance they get.
So it kind of gets into that. These are great because these questions are all kind of feeding on each other. So also, and I know we'll wrap things up here in a minute, but do you sometimes struggle with your own sense of what the right outcome or what the right results should be?
I do. I think that's a natural human, reaction. And indeed, when we start a mediation, we very quickly find that there are parts of us that are noticing which side has read getting to yes and which side maybe read getting to yes but didn't get it or they never read it. Um,
Hmm.
there's one party that's going to be a collaborative bargainer and one that's going to be a competitive bargainer. And so, of course, we have feelings, but part of our job as mediator is to compartmentalize, notice those feelings, notice those parts, and bring to the fore the parts of us that are going to be skillful, even handed, and empathic, and let the judgy parts just be off to the side somewhere.
Yes. All right. Let's wrap it up there. I think that's good. I see 11:11 on my clock. I want to let everyone get back to their day. There was a couple more questions. One is about recommended resources. I would just suggest if folks are interested in resources that David talked about today to reach out. You've got his email. Reach out to David, and he can send that your way. David, I'm gonna just end it with one final remark from you. What maybe a closing reflection. One thing I
Yeah.
was curious about, as you're talking is, you've been reflecting on so much here today and talking about so much. What continues to give you hope about the work we do as mediators?
I feel such gratitude to be part of the community of peacemakers, and that sustains my hope that we can bit by bit, one case at a time, make the world a better place. And I'll quote my rabbi, Rabbi Darby Lee, and there's a quote in the book from him. He talks about how in the Jewish tradition, one of our commitments is tikkun olam, to heal the world. And of course, this we hold in common with other faith and wisdom traditions. It's not unique to Judaism. But in the Talmud, there's a statement that says, you don't have to fix everything, but neither are you free to desist from the work. And Rabbi Darby says, and when you feel daunted by the brokenness of the world, the enormity of conflict and difficulty and suffering, remember that there may be certain corners of the world where we are uniquely situated to do good. And my hope for all of us in this Zoom space and in the mediation community is that we continue to find those places where we've been invited in to the sacred, vulnerable space of conflict, and we have a unique opportunity to do good. And I wish that for all of us. And thank you, Liz, and thanks to the section. Thanks for everybody who showed up for this. It's very rewarding to be part of this community. Thank you.
Well, thanks for all of that, and thank you. And I'm going to make that a Davidism. Continue to do good. We'll make some T-shirts, and they'll be for sale. No, just kidding. Um, but no, thank you. Continue to do good is a great message, and I think gives all of us hope. So thanks, David, for being here. It was a pleasure talking with you, and thanks to all of you in the audience. It was great to see you here. Have a good rest of your what day is today? Thursday. Have a good rest of your Thursday. Okay, take care.
I know.
Bye.